Hey guys, sorry that I have not been able to come back to school at the moment. I had a pretty horrific accident and now have uh, many screws and plates in my foot just to keep it attached to my body. So, in lieu of me being there, I'm going to record a short video trying to get permission from the surgeon to be back as soon as possible, but just managing that. The expectation is that you are all keeping up with your pre-work. I've received coursework from 2 people, so if you haven't put it in my office for someone to pick up or taken a photo and email it to me, I'll be putting you at risk. Okay, let's talk about common law today. Really interesting topic, can be a little tricky to wrap our heads around, but as legal beagles, it's vitally important. So please be taking notes. This will go for about 5 to 6 minutes. I know everyone loves the sound of my voice almost as much as I do, so here we go. Okay, yesterday we looked at statute law. Statute law made by Parliament. In 2020, the vast majority of laws are statute laws. Okay, we have a Parliament now that's democratically elected. They see as their job to make laws on behalf of the people, and the easiest way for them to enact policies, so to fulfill their promises, not that that happens that much, is to pass legislation through Parliament. Pass it through the lower house too easy because the government always has a majority, and then negotiate their way through passing it through the upper house. Governor General gives it the stamp of approval. This is not always how laws were made, though. Okay, traditionally law was under the control of the church. Later, it was under the control of the king, but we still needed a way to resolve disputes. So, again, remembering that our legal system is largely borrowed from the UK, people would have these disputes, and in order to have them resolved, these travelling magistrates would roam around the countryside, and they would do it for a fee. They would apply either a natural law, so this is this idea of natural laws of justice that are derived from religious writings or from philosophy, and say, okay, we've got 2 people, they've had an argument, what is an appropriate resolution? Particularly in civil law, okay, how are we going to resolve this? Who is in the right, who is in the wrong? And it was up to the magistrate to make that call. You also had individuals who would carry out criminal legal functions in this way as well. What's the law? What is the punishment? But largely laws were made in this way. So judges were moving around, and judges were hearing cases and determining the appropriate law. They may be applying law that was passed by the king. But the key problem with this is, well, if I'm living in Sussex in England and I commit a certain act and receive a punishment, why should that be different to the punishment that is meted out to someone living in London? Okay? Or if I have had a dispute with my neighbour, why shouldn't that be resolved in a similar way? So in order to ensure that there was some consistency, the doctrine of precedent was developed. The Latin principle stare decisis simply means to stand by what is decided. And the doctrine of precedent tells us that if a decision has been made previously in a case with similar facts, ideally we want to follow that decision, okay, to enable citizens to know what the likely decision in the case will be. Makes it easier for the judge to make their decision. So allows for consistency in the law. However, I only have to stand by the decision if a superior court has made it. So in our Victorian context, we know we've got the Magistrates Court, up to the County Court, up to the Supreme Court. If the Supreme Court makes a decision on a particular case, determines a legal principle, it has to be applied in the county and the Magistrates Court. Okay, so I can be confident when I'm going to either of those courts what the most likely decision of the magistrate or of the judge at the county court will be. Okay, so it allows for consistency. If I'm a magistrate or a judge in this case and the Supreme Court's made a decision, I'm bound by what they say. We recognise in the legal system that the judges of the Supreme Court are legal experts. Their level of expertise and qualification is greater than that of those in the county and magistrate court, so I have to follow that case if the facts are the same. Okay? This is again another old image of an old trial, the way it used to work, judges moving around making common law. Again, they didn't have heaps of statute law written down to apply. They would make decisions based on what other judges had done previously. Okay, this is at the heart of common law. Common law has been really important in developing new legal principles. So today, if the CRT who's taking the class was to walk out of the class halfway through and you started jumping on the table and fell off and injured yourself, you could sue the CRT for negligence. Okay, they have a duty of care over you, just like any teacher does. Just like when you're at a cafe. One time when I was living in China, I was at university in the canteen, and I used to have a bowl of tomato and egg noodle soup, maybe every second day. It cost me $1. Really delicious. One day I found a piece of steel wool in my tomato and egg noodle soup. Legal system's a bit different in China. They have a duty of care over me to ensure that I don't eat a piece of steel wool. In Australia, I could have taken legal action on that behalf. These are settled legal principles, but it hasn't always been that way. It was up to a judge to determine these new legal principles to be applied in the future. So the Donahue and Stevenson case, which I think you've already looked at or you will look at, a woman was given, a woman was at a cafe with a friend. Her friend bought a bottle of ginger beer. In that ginger beer was a rotting snail. She drank the beer, got really sick, and so wanted to sue the manufacturer of the ginger beer bottle. And what the court said is, yes, you can, because the person making the ginger beer, has a duty of care. They've got a responsibility to take reasonable precautions to ensure that the people who are drinking their products don't get harmed. Very common sense, but at the time was not an established legal principle. In all future cases, that has now been applied, it has been extended, it has been built upon, but that is the legal principle that's enforced because of the doctrine of precedent. Okay? And without common law, we don't have the law of negligence. However, as we know, the vast majority of laws are now statute law. So where does that leave common law? Where does that leave the decisions of judges? A couple of things. One, often Parliament will take a previously existing common law and they will write it into statute law. So there is now a written law of negligence about in the Wrongs Act in Victoria. Sometimes they will leave it knowing that it will be applied. In no statute is there a written law on murder. Okay, murder is a common law that was developed over a long series of cases to determine, well, what does it mean to actually kill someone? Does it have to be a person? How old does the person have to be charged with murder? That isn't written down in statute in Victoria. That exists as a common law. When Parliament passes laws, though, they're often very broad so that they can be applied to a vast range of situations. Okay, so the role of judges now is to interpret statute. So, okay, what was Parliament intending when they created this law? How does it apply to this specific situation? Okay, a great example is the studded belt case. Okay, the Parliament passed the Regulated Weapons Act, which brought in strict punishments for the carrying of weapons, enabled police to be able to arrest people for carrying them. A young boy was in a McDonald's car park and he was wearing a studded belt, and he was charged under the Regulated Weapons Act. The police said that is a weapon. It's really just a really horrible fashion choice. But it was up to the court to interpret that statute. What did Parliament intend when they created the statute? What do the words in the statute mean? They decided that a studded belt is not a weapon. Because of the doctrine of precedent, all future cases that are similar must be applied in the same way in lower courts. Okay, this was a Supreme Court case. So in the county court and the magistrates court, if someone was arrested wearing a studded belt, the court would find them not guilty. perhaps there is a similar item. Maybe someone's arrested for wearing a studded, neck choker or a wristband. Again, the judge would apply based on the legal principle that's already been established. Doctrine of precedent allows for consistency in the law and in the application of law by judges, and also for some flexibility where the facts are different, or where a much higher court, decides to change the original precedent. Okay, I've almost talked for 11 minutes, so I'm going to stop there. As long as you remember, the courts apply precedent, they create new legal principles, they follow what has been decided before them, and largely their role now is to interpret and apply statute. You are good as gold. All right, see you later.